Yeah.
This is a clear violation of the homeowner's agreement.
Mhm.
I expect this removed by the end of the week.
We believe we are in full compliance.
They sent a resident to charge their vehicle on my charger while I was watching from my kitchen window. Not a stranger, not someone who had wandered in from outside the development. A resident of Maplewood Glen sent, I would later document, at the specific direction of the HOA board president, who had convened a meeting 2 days earlier at which she had declared that privately installed EV charging equipment within the development's common parking structure was, per her interpretation of the HOA's governing documents, a shared community resource accessible to all residents. The resident who arrived at my charger at 2:17 on a Thursday afternoon was a man named Gerald who lived in Building 3 and who had the slightly uncomfortable manner of someone executing an instruction he was not entirely certain was correct. He scanned the QR code on my charger's access panel. The charger rejected his scan. He looked at the charger. He looked at the QR code. He scanned it again. It rejected again. Then he called someone on his phone. Then he left. My name is Priya Anand. I am 44 years old. I am a technology attorney specializing in intellectual property, software licensing, and the legal frameworks governing connected devices. When the Maplewood Glen HOA board president declared that my privately installed, personally funded, individually registered EV charging equipment was community property, she made a claim against property that I had designed from the moment of its installation to be legally and technically unassailable in ways that she did not understand, and that took me approximately 2 weeks to demonstrate completely. The demonstration was not dramatic. It was documentation. It was contract law. It was the specific application of the legal frameworks I work with professionally to a situation that someone had decided to test without understanding what they were testing. I had been waiting for this moment since the day I installed the charger, not because I anticipated the specific form the challenge would take, but because I understood the HOA environment I was operating in and had designed the installation to be defensible against the specific categories of challenge that environment could produce. Comment below where you are watching from. Because this story ends with a board resolution formally acknowledging private ownership of privately installed charging equipment, a board president who moved to a different development 8 months after this resolution, a legal framework that 3 neighboring HOA communities have since adopted for EV charging governance, and a charger that has never, for a single session since the day it was installed, been accessible to anyone whose access I had not individually authorized. But it begins with a parking structure and a decision I made before I installed anything. Maplewood Glen is a 112-unit condominium development in Santa Clara County, California, built between 2014 and 2018 as a transit-oriented community near a light rail station. The development attracted a resident profile that leaned heavily toward technology industry professionals, which meant, among other things, that EV ownership was high and charging availability was a persistent community conversation. The development had been built with 3 Level 1 charging outlets in the common parking structure, which had been adequate for the EV population when the development opened in 2018, and which had become grossly inadequate by the time I purchased my unit in 2021. When approximately 30% of residents owned electric vehicles, and the 3 available charging outlets were managed through an informal reservation system that worked exactly as well as informal reservation systems manage things in communities of technology professionals, which is to say imprecisely and contentiously. I purchased my unit in 2021 with a specific plan for my parking situation. My assigned parking space was number 47 in the eastern bay of the underground structure, away from the 3 existing community chargers. I had selected Unit 47 partly because of the parking space location, which I had assessed during my due diligence walkthrough. Space 47 was adjacent to an electrical panel that served the eastern bay. The panel had capacity for additional circuits, which I had asked an electrician to assess informally before I closed on the purchase. The electrician had confirmed that a level 2 charging circuit was feasible from that panel to space 47 without significant infrastructure work. I had closed on the purchase with that assessment in hand. Before I applied for installation approval from the HOA, I spent 3 weeks reading the Maplewood Glen governing documents with the attention I applied to commercial contracts. California Civil Code Section 4745 gave me the right to install an EV charger in my assigned parking space regardless of HOA restrictions, provided I complied with reasonable HOA conditions, obtained required permits, and paid all installation costs. The HOA could not prohibit the installation. It could require that I pay costs, obtain permits, carry insurance, and maintain the equipment. It could not claim ownership of the equipment I installed. I submitted my installation request to the HOA board with a cover letter that cited the specific civil code section, that proposed the conditions the HOA would typically impose, and that included a draft installation agreement that I had prepared myself. The draft agreement was thorough. It specified that the charging equipment was my personal property. It specified that access to the charger was controlled exclusively by me. It specified that the HOA had no ownership interest in the equipment and no authority to direct its use. It specified that I was responsible for all maintenance and that the HOA was responsible for no aspect of the equipment's operation. It specified that, upon sale of my unit, the charger could be removed or could be transferred to the buyer at a price I negotiated independently, with no HOA involvement in that transaction. The board had taken 6 weeks to respond to my installation request and had responded with a modified version of my draft that changed several provisions in ways that were legally insufficient to affect the core property rights I had specified. I had accepted the modified version after redlining the portions that were unacceptable and negotiating by email over 4 exchanges with the board president at that time, a man named Richard who had approached the negotiation with what I assessed as a genuine attempt to reach a workable agreement. The final installation agreement was signed by both parties, notarized, and recorded as a memorandum with the Santa Clara County Recorder's Office. I had insisted on the recording. Richard had asked why it was necessary. I had said that recording created a public record of the agreement that would survive any subsequent dispute about its terms. He had agreed. The agreement was recorded in October 2021. I had the charger installed in November 2021 by a licensed electrician with a county permit. The charger was a level 2 unit, 48 amp, capable of adding approximately 30 miles of range per hour. It was a commercial-grade networked unit, the kind that charging networks use, with a cloud-connected management system that allowed me to control access through a smartphone app and the QR code system on the unit's face. Access to the charger required either a physical card that I had programmed and could issue individually, an app account that I had individually authorized, or QR code authentication that was tied to the same authorization system. Nobody could use my charger without my specific prior authorization. I had authorized one person myself. The charging network's terms of service were in my name. The charger's serial number was registered to my account. The equipment purchase receipt was in my name. The installation permit was in my name. The recorded installation agreement was in my name. The electrical circuit was connected to a sub-meter that billed electricity to my account directly. Nothing about the charger had any relationship to the HOA, except the recorded agreement specifying that the HOA had no ownership interest in it. Richard had resigned from the board president position in early 2022 for reasons unrelated to anything I was involved in. He had been replaced by a woman named Constance Webb, 58, who had come to the board president position from the HOA Social Committee with the specific energy of someone who had been waiting for authority and intended to use it. Constance had a philosophy about community resources that I had observed at 2 board meetings before the EV charger situation materialized. Her philosophy was that individual amenities within a shared community space created inequity, and that the board's role was to manage community resources for collective benefit. It was a coherent philosophy in certain contexts. It was not coherent as applied to privately owned equipment installed in a private parking space under a recorded legal agreement. I had understood, from the moment I observed Constance's philosophy in action, that the charger was going to be tested. I had designed the charger to be testable. I had simply been waiting to see what form the test took. The board meeting at which Constance declared my charger a community resource was a Tuesday evening in March. I had not attended because I had a client call that I could not reschedule, but I received a summary from a neighbor who had attended and who texted me during the meeting with the specific helpfulness of someone who understood that what they were witnessing was relevant to someone they knew. The summary was that Constance had presented a new EV charging equity initiative under which all privately installed charging equipment in the common parking structure would be designated as shared community infrastructure, accessible to all residents on a rotating reservation basis, with the private installer retaining a priority reservation slot but not exclusive access. She had cited a provision of the HOA's master deed that described the parking structure as a common area element to support the argument that equipment installed in common area was subject to community governance. She had not cited California Civil Code Section 4745. She had not mentioned the recorded installation agreement. She had moved the initiative to a board vote and it had passed 4-1, the one dissenting vote being from a board member named Alan who had been on the board when the original agreement was negotiated and who had texted me separately after the meeting to say he had voted no and that I should call him. I called Alan first. He said, "Priya, she does not know about the recorded agreement." I said, I assumed she did not, given the argument she made. He said, "What are you going to do?" I said, I am going to let her implement the initiative and wait for the first enforcement attempt. He said, "You are going to let her run into it." I said, "The recorded agreement is a public record. It has been recorded at the county recorder's office for 17 months. The argument she made at tonight's meeting is directly contradicted by that agreement and by the civil code section she did not cite. I am going to let that become apparent in the clearest possible way." He said, "The clearest possible way involves letting her send someone to your charger." I said, "Yes." He said, "And then?" I said, "And then I am going to document what the charger does when someone who is not authorized tries to use it, and I am going to let that documentation begin a process that ends with the board understanding exactly what they voted on tonight and what it costs them." He said, "How long do you think this takes?" I said, "Not long. Constance is efficient. She will implement this week." He said, "I am going to stay out of it until you need me." I said, "I may need you to attend a board meeting." He said he would be there. Gerald arrived at my charger at 2:17 on a Thursday. He scanned the QR code twice, both scans rejected, and left. I had the rejection logs from my charger's management system, which time-stamped every access attempt and showed whether the attempt had been authorized or rejected. Gerald's 2 scans at 2:17 and 2:19 were in the log as rejected unauthorized access attempts. I captured screenshots and downloaded the log file. I called my attorney, not Sandra, a different one for a different kind of problem. Her name was Monica Chen, and she had been my partner at a firm before she went solo in 2019. She handled HOA and property disputes, among other things, and she understood technology law, which was relevant because the technical aspects of the charger system were going to be part of the analysis. I described the situation. She read the recorded installation agreement, which I had sent her a copy of when it was recorded in 2021. She said, "Priya, the board voted to declare your privately owned equipment a community resource after it was installed under a recorded agreement specifying it was not a community resource." I said, "Yes." She said, "They did this without citing or apparently consulting the agreement." I said, "Yes." She said, "And the civil code section." I said they had not mentioned it either. She said, "This is going to be a short proceeding." I said, "I want it to be a thorough one." Short is fine, but I want the outcome to produce a clear record that this question has been resolved, and not a quick capitulation that leaves room for someone to revisit it. She said, "You want a formal resolution, not just a withdrawal." I said, "I want a board resolution formally acknowledging the legal framework for privately installed EV charging equipment in this development, so that this question does not arise again when Constance is replaced by someone else who has the same idea." Monica said, "That is a more ambitious outcome than simply getting them to back down." I said, "I know." She said, "It is also the correct outcome. Let me draft the demand." The demand letter Monica sent was 14 pages. The first 4 pages described the California Civil Code Section 4745 framework, including the specific provisions governing HOA authority over private EV charger installations, the limitations on HOA restrictions, and the prohibition on HOA claims of ownership over privately installed equipment. The next 3 pages describe the recorded installation agreement, its terms, and the specific provisions that directly contradicted the board's equity initiative. The next 4 pages describe the legal consequences of the board's action, including the civil code's fee-shifting provision that allowed a court to award attorney fees to a homeowner who successfully challenged an HOA action that violated Section 4745, and the potential liability the HOA had created by instructing Gerald to access equipment it did not own without authorization. The final 3 pages described what Monica was requesting on my behalf, which was a formal board resolution within 30 days rescinding the EV Charging Equity Initiative, formally acknowledging the legal framework for private EV charger ownership under California Civil Code Section 4745, formally acknowledging the terms of the recorded installation agreement for my charger, and committing to apply that framework to all future EV charger installation requests in the development. She included a draft of the board resolution she was requesting, which was precise and thorough, and which I had reviewed and approved before she sent it. The letter was sent to the full board, certified mail and email, on a Monday morning in April. Constance received it. I know this because she called the HOA's attorney that afternoon. The HOA's attorney, a man named Warren who had handled the HOA's legal matters for 6 years and who had not been consulted before the EV Equity Initiative was implemented, called Monica on Tuesday morning. By Monica's account, the call was brief. Warren said the HOA recognized the recorded agreement and the civil code framework and would be responding to the demand. He said Constance had not consulted him before the initiative was implemented. He said he was now involved. Monica said she appreciated that and that she looked forward to the board's response within the 30-day window. Warren said he expected to have a response considerably sooner than that. The board held a special meeting on the following Thursday, 8 days after Monica sent the demand. I attended this meeting. I had cleared my evening for it. The meeting room had the specific atmosphere of a proceeding that everyone in it understood was going to produce a predetermined outcome, and that the purpose of the meeting was the formal record of the outcome rather than any deliberation about what it should be. Warren was present as the HOA's counsel. Monica attended with me. Constance was at the head of the board table. She had the composed expression of someone who had been briefed by her attorney and understood her position precisely, and was not pleased with it. Warren opened by presenting his analysis of the legal framework, which tracked Monica's demand letter with the close correspondence of 2 attorneys who had reached the same conclusions from the same governing law. He cited California Civil Code Section 4745. He cited the recorded installation agreement. He cited the access attempt rejection logs that I had provided as documentation of Gerald's unauthorized access attempt, and that created, under his analysis, a potential liability for the HOA for directing a resident to attempt to use equipment the HOA did not own without the owner's authorization. He said the EV Charging Equity Initiative as implemented was inconsistent with the legal framework and that the board should rescind it and adopt a resolution clarifying the framework going forward. Constance said she had understood the parking structure to be common area and the equipment installed in it to be subject to community governance. Warren said the Civil Code created a specific carve-out for privately installed EV charging equipment that superseded general common area governance principles. He said the recorded agreement had further specified the property rights framework before the first charger had been installed. He said the initiative had been implemented without consulting the agreement that was in the HOA's own files and without consulting him. He said he was recommending the board adopt the resolution Monica had drafted. The board voted 4 in favor of adopting the resolution, including Allen, who voted yes with the expression of someone who had known this moment was coming. 1 abstention, which was Constance, who did not vote against the resolution because Warren had apparently explained to her that voting against a resolution he had recommended on clear legal grounds would create individual liability concerns for board members who voted no. The resolution was adopted. The specific language of the resolution was the language Monica and I had drafted, which meant it said exactly what I had wanted it to say about the legal framework for private EV charger installations, about the HOA's acknowledgement of the recorded agreement for my charger, and about the HOA's commitment to apply the framework to future installations. Monica had the resolution recorded as an amendment to the existing memorandum at the Santa Clara County Recorder's Office within the week. The recording created a public record of the board's formal acknowledgement that would be visible in any title search, and that would be part of the chain of documentation for the development going forward. I filed a summary of the resolution and the legal framework with 3 neighboring HOA communities, whose residents I knew were navigating similar EV charger questions. All 3 communities were wrestling with the tension between individual EV charging needs and common area governance. The summary described the California Civil Code framework, the importance of recorded installation agreements, the technical access control systems that made private ownership practically enforceable, and the board resolution that had resulted from Maplewood Glen's experience. 2 of the 3 communities adopted formal EV charging governance policies within 6 months based in part on the framework the summary described. The 3rd was still in deliberation at the last update I received. Constance Webb resigned from the board president position in November, 8 months after the resolution. Her resignation letter cited a desire to focus on personal priorities. The new board president, a man named Dennis Park who had been on the board for 2 years, called me after he was seated. He said, "Priya, I want to make sure I understand the EV charging framework before anything comes up." I said I appreciated that and would be happy to walk through it. We had a 40-minute call in which I described the Civil Code framework, the recorded agreement, the technical access control system, and the documentation I maintained. He said, "You had all of this ready before she declared your charger community property." I said yes. He said, "You knew she was going to try something." I said I had assessed that Constance's governing philosophy was likely to encounter the charger eventually and had designed the installation to be defensible when that happened. He said, "Designed it." I said yes. He said, "You are a technology attorney." I said yes. He said, "And so you built a system that is legally unassailable and technically impenetrable and documented everything in a public record." I said, "I built a system that worked the way I needed it to work, and that was documented in a way that would produce a clear outcome if it was challenged." He said, "What made you record the agreement at the county recorder's office?" That is not something most people do with an HOA agreement. I said, "Recording creates a public record that survives any dispute about what the parties agreed to." I learned that from working with commercial contracts for 15 years. When something matters enough to document, it matters enough to record. He said, "And the charging network registration and the sub-meter and the equipment receipts." I said, "Ownership is documented by records of purchase, registration, and usage." I maintained all of those records from the day of installation, because the question of who owned the charger was going to be answerable only by those records if it was ever challenged. He said, "Priya, you were building the case before there was a case." I said, I was building the documentation that the case would be decided by if there was one. I prefer not to have the case. The documentation is why I did not need to have a long one. He said he appreciated that clarity. He asked if I would be willing to consult on the development's broader EV charging policy going forward, as the HOA was expecting more installation requests and wanted to get the governance right before they received them. I said I would be glad to. I am a technology attorney. Governance frameworks for connected devices are what I do. The charger is in Space 47, Eastern Bay, Maplewood Glen underground parking structure. It is registered in my name, controlled by my account, accessible only to individuals I have specifically authorized. The rejection log has recorded 4 unauthorized access attempts since installation, all in a 2-week window in March and April, all resulting in rejections, all documented in the file Monica maintains for the matter. The log has recorded no unauthorized access attempts since April. The resolution is recorded at the Santa Clara County Recorder's Office as a public document. The installation agreement is recorded. The memorandum is recorded. If someone in this development or any other development with a similar situation wants to know how a private EV charger was defended against an HOA claim of community ownership, the documents are public and the framework is clear. Documentation before installation, recording before challenge, technical access control from the first day, legal framework cited in the agreement before the agreement is signed. Build the thing correctly and the challenge resolves itself. That is the framework. That is what happened. Hit the like button if you believe that private property remains private property regardless of where it is located, and that the word private carries its full legal weight in any document that uses it correctly. Subscribe for more stories about property rights, legal frameworks, and the specific results that follow when documentation is built before it is needed, rather than assembled after the problem arrives. And if you are installing an EV charger in an HOA community, read California Civil Code Section 4745 or your state's equivalent before you start. Have an attorney draft the installation agreement. Record the agreement as a public document. And ensure your charging system has technical access control that makes private ownership practically enforceable from day one. The documentation is the defense. Build it before you need it. Framed thumbnail text. CLAMED, my EV charger was community property. Subtext, the legal trap she never saw coming.